Welcome, everybody. I hope you've had a chance to grab a little bit of lunch, and I know you're looking forward to our talk today. I wanted to just welcome those of you, some habitual attendees at the Law, Religion, Social Thought colloquium, and some for the first time. The idea behind this colloquium has always been to bring critical and different perspectives on the study of religion and how it interacts with law, how it interacts with politics and social thought into the law school, both for the benefit of those of us who are spending most of our times inside Osgoode Hall Law School, but also so that we can have a place where people from different disciplines at York and within the city are speaking through some of these issues. And so you will see a contingent come in as they're adjusting to the new subway reality. They were a little optimistic coming from the U of T end of it, but are they just arriving? I've partnered for this colloquium with the Religion in the Public Sphere initiative at the University of Toronto in the Department for the Study of Religion, and they'll be arriving soon. So really the pleasure for me in these is to welcome to Osgoode and to bring in some of the people in the field of the study of religion and the study of religion and society, the people that I'm reading from and learning the most from, up to Toronto into Osgoode to introduce them to you, and that's certainly my pleasure today. I'm going to be introducing to you Greg Johnson, who is Associate Professor of Religious Studies at the University of Colorado in Boulder, and the Director of the Center for Native American and Indigenous Studies, which is just a remarkable center at Colorado. He was trained in the famed religious studies program at Chicago, and is become, over the years, one of the leading experts and just one of the most insightful voices in the study of religion, and in particular, Indigenous religion and the relationship between indigeneity and spiritual traditions and the law. And you really know someone's true wisdom as a person when you see, well, what are they going to work on for their research projects? And if they're doing field work, where are they going to pick to do their field work? And so Greg has committed himself to the admirable task of spending his time in Hawaii, studying Indigenous religion and all sorts of interesting ways you're going to hear about today. His focus in that work has been on reparation. There's repatriation. There's been a lot of work in recent years on burial sites. And recently, a considerable amount of work on sacred sites, and that's something that resonates for us in Canada right now with recent events. It is something that Greg is going to be speaking from today. Just a word of note, he's involved in a fascinating international indigeneity and religious expressions project that's brought him to Indigenous communities all around the world, and might be a chance to chat a little bit about that in questions. But most recently, if you want to pick up his work, he's the co-editor of the Handbook on Indigenous Religion, (S) Religions, and a forthcoming book called Irreverence and the Sacred, Critical Studies in the History of Religions from Oxford. It's one of my favorite religious studies scholars and thinkers, but Greg is also just simply one of my favorite people in the field, and so I'm super excited to have him here, so I hope you'll join me in welcoming him to the colloquium.
All right, thank you. Well, thank you all for being here on this snowy day. I'm excited to be here. Thank you to Ben. We've been friends and colleagues for some time. I should have known that he's would be such a good host. I told him if the day job doesn't work out that he could do, some sort of a hosting business, because from the very start of making plans to just now, everything he's done has made me feel super welcome. So thank you, Ben. And thank you to the colloquium, to Osgoode Law School, to the Toronto Religion Program, and everybody else who had a hand in this. I have a lot of material to cover, so I'll just jump right in. But first I want to contextualize things a bit. In Hawaii, how many people have been to Hawaii? I just get a sense. Okay, a fair number. How about Hawaii Island, or the Big Island? A couple people. Okay, that's where we'll be, on the Big Island. In particular, we will be on the slopes of Mauna Kea, which reaches almost 14,000 feet in elevation. It's the highest point in Polynesia and world-renowned site for telescopes. So that's where we'll spend a little bit of our afternoon. And to give you a kind of embedded sense of being there, I'm going to have you watch just 2 minutes of video that really brings to life, I hope, what I'll be talking about. And the deal is this. For the last 4 years, there have been ongoing and intense protests on Mauna Kea by Native Hawaiians against further telescope development on what they regard as a sacred mountain. Now, the protesters are there for a variety of stated reasons. Some just say the mountain is too sacred, period, and will tolerate no negotiation, no telescope, so forth. But the main claim of most of the protesters is that the state has failed to adequately consult them about their cultural practices, their living traditions, and so forth, to meaningfully engage in cultural impact studies, environmental assessments, related kinds of things. So they're just seeking to have the state enforce those rules, laws, and processes. Numerous people have been arrested along the way. It's an occupation movement, much like movements you've seen here in Canada with First Nations people, and much like the Standing Rock protest, not as large, but camps of people on the mountain blocking the road, blocking construction access, and so forth. As a scholar of religion, what's drawn my attention is how very much religion is front and center. Most every act is governed by protocol of some form, ritual protocol, of prayers, of chanting, of genealogies relating people to place, not just any place, but that place. And I've spent quite a bit of time on the mountain during these protests and trying to take stock of this sorts of religious action. And as a scholar of religion, I can say, yeah, there's a lot of religion happening there, and it sometimes materializes in objects. We're going to talk about one of those today. And what's really drawn my attention and what I want to think with you about is the fact the state, all of this remains quite invisible to the state. There have been subsequent hearings that I'll describe related to the protests, and the state is not able to see this religious action, take stock of it, weigh it in any meaningful way. What the way out of this bind is, I don't know, and I hope to brainstorm with you about that. Okay? So Ben, if we could have those, just a little bit of the video. During the Q&A, I'd be happy to answer questions about the protests themselves and some of the ritual action. Just want to point out at this juncture, you notice a lot of young people. This is an immersion school generation of activists and religious leaders. Kids who started in the immersion programs in the 1980s are now young adults, command their language in a really powerful way that hasn't been the case in Hawaii for decades. And as it goes in Hawaii, as with many indigenous places, to command language is to necessarily be embedded in place and genealogy. And so these young adults, that sense of language has made them committed to their places, and that sort of attachment is really profound to me. As someone who's worked there for a number of years, it's really emergent right now, this strength of the sense of commitment. Okay. The problem, in a nutshell, failure to appear. And I mean this for tradition in general in the telescope case, but I'm going to start with a nutshell example here. This is Kalekoa Ka'eo. He's a University of Hawaii Maui professor, but he's also a renowned activist, religious leader, so forth. This picture was taken less than 2 weeks ago. He was in Maui in court, and therefore some of the telescope protests, and he insisted on speaking Hawaiian in court. It's a state-recognized language, and the judge asked him in English, "Are you here, Samuel Kalekoa Ka'eo?" And he answered in Hawaiian, yes. The judge asked 3 times. Then he sent the bailiff out in the hallway to ask the same question in English, and when the answer wasn't forthcoming, issued a bench warrant for failure to appear. Not contempt, not something else, failure to appear. And this set off a major storm in Hawaii. It's still going on right now in the legislature, in the press, elsewhere, about what does it mean for a language to have state recognition, and yet when someone exercises that right in court, be told that they did not appear. They are quite literally invisible. So I submit that that kind of problem of the state in principle affirming something, but in practice radically denying it, really frames so much of what's going on in Hawaii today. Okay, so Mauna Kea, well, first of all, go. Probably the most utility I can offer today is as a travel guide. Email me, Ben knows how to reach me. Be happy to set you up. It is so beautiful. It's a remarkable landscape. These are called pu'us. They're little volcanic cinder cones. We're almost at the summit, so 13,000 feet. It's so dramatic and wonderful, and for Hawaiians, a site of abiding tradition. It's also the site of a proposed 30-meter telescope. TMT stands for 30-meter. Next generation of largest telescopes in the world, be able to see into deep space and deep time, so forth. This has been in the works for almost 20 years. There have been various administrative processes up to now kind of paving the way for this. The funding is in place. It's $1.4 billion. And in case you wondered who some of the partners are, along with several U.S. institutions, the Government of Canada through the National Research Council, the Government of Japan, India. So suffice it to say, global players, global money. This is no small deal. And so one of the frameworks for thinking about this is how do Native peoples on their own land stand a chance when this is the kind of resource brought to bear against them? Not always in nasty and pernicious ways. It just sets a tremendously asymmetrical frame. So what I want to talk about here is failures, think about some comparisons, and I hope talk about futures. So failures in the sense of this failure to appear. How has tradition not appeared throughout these processes? And then to brainstorm with you about comparative relevance here in Canada, and to genuinely think, I hope, about is there a way out of this sort of an impasse? Or should religion not even be part of the equation here? Is that the problem to start out with? Okay, to get at these sorts of questions, we're going to focus in on one object. This is called an ahu. This is on the site of the 30-meter telescope where it's proposed to be built, just off the summit shoulder. There are 13 other telescopes on the summit. You can see 2 there. Ahus in Hawaiian tradition are altars, or offering sites, place where people would come to commemorate something, usually a battle. These religious sites are fundamentally tied to a history of strife in Hawaii. In battle, after or before a battle, an ahu would be built to consecrate the meaning of that struggle, draw upon ancestral wisdom in that place with regard to that struggle. There's a deep tradition of this kind of behavior of where politics and religion are articulated intensely. This particular ahu and a twin ahu just out of the picture were built on June 23rd and June 24th, 2015. So in the 2 days prior to the protest you just witnessed. The protesters had gotten word from the state that the state was going to escort the construction vehicles up the mountain, and that despite the fact that there was a court case going, there was no injunction. The state made it known that they would bring police up, try to break the barricade, and escort the construction vehicles up. So in preparation for that moment, those days, many of the kia'i, or the cultural practitioners, went to the summit and built these ahus, consecrated them in ceremony. Multiple long chants, genealogical chants were performed, so forth. And that's all in video. It's easily, there's a documentary history there. This is what's in question in some of the debates that are unfolding now. And so we're going to use this ahu, this material site, to help focus us. As you saw in the video, these women are incredible. And they stand as an example of the kind of ritual vitality on the mountain. What was happening in that video shot and in this still is they're forming a line across the road as a protection barrier. And when the police came, it's not embedded in law, but it's a practice of the Hawaiian police that if people are in ceremony, they won't be arrested. So long as you stay in visible ceremonial kind of comportment, the police will let you be. So they chant, they get in the road, block the road, and they chant and chant and chant. Finally, the police were losing patience and began to arrest people. But this notion that religion is the way to create a buffer, but that doesn't delegitimate it. In Hawaiian practice deep into time, this is how it's worked. If people needed space before the war, they would chant, they would go into songs. So I want to paint a picture where this is continuous with lots of prior practices. So there were lines of people up and down the mountain this day, June 24th, 2015. And the idea of the protectors, as they call themselves, or protesters, was to space themselves about every 30 meters or so that the next line couldn't hear what the police were saying to the previous line, so that when the police got there, they had to read them their rights, explain what they intended to do, and so forth. It was a stalling tactic, and it worked. They didn't make it up the mountain. That day, that's what you saw at the end of the video, was the agents from the Department of Land and Natural Resources saying, okay, we're giving up for today, we're going down. Part of why they gave up that day is because some young Hawaiian men broke the prevailing ritual protocol, which is kapu aloha, to act in peace. It's a nonviolent ethic learned from Martin Luther King, from Gandhi, from others, but also sources in the Hawaiian tradition of nonviolence, non-aggression. Some young men stepped outside of that and rolled boulders into the road to prevent vehicles from coming up, and that's when the state said it's a public safety issue. That's what you heard the man say. At that same time, people built ahus, these altars, along the roadways and so forth. I'll pick up that thread in a moment. Just to emphasize that this is an occupation movement, so it echoes the Alcatraz movement in the US from the late 1960s. Also the Wounded Knee occupation, Standing Rock, closer to your home here, Oka, Gustafson Lake, Barrier Lake, and I know there are countless more occupation and protest movements among First Nations people. So I assume this resonates in some basic kind of way. I look forward to talking about differences too. And it's a global indigenous movement. Many American Indian allies came to Mauna Kea, Apache, Mohawk, Navajo people, Cheyenne, others. As you can see from the flags, Maori, someone from the state of Florida brought their flag, and they're like, Hawaiians are like, oh, okay, love you guys. And anyhow, so this sense, much as with Standing Rock, that it's about a specific place, but it's also about indigeneity writ large and about holding states accountable. So again, back to this moment of the civil disobedience on June 24th, 2015. And I was there during these protests, documented much of what was happening. So I mentioned that on that day, various ahus were built. This is just off the side of the road at 11,000 feet. It's called Ka'uakoko, the Shrine of the Blood Rain. There's a historical precedent for an ahu with this name down in the valley below, commemorating a battle from the 1500s. Hawaiians that day thought this was a major battle. We should consecrate it as such, name it. It right away became a site of ritual action. Namely, I mentioned that there were some young men who rolled boulders into the road against the prevailing ethic. They got together with elders at this ahu the next day, in hands, performed what's called ho'oponopono, that is making right. That is to say, we breached our protocol, let's make good on this, let's move forward together. My point, manifestly religious action, by any reasonable definition, took place at this manifestly religious site, which was then bulldozed by the state of Hawaii several days later. That is where it sat. Now it's a site of pilgrimage, of people visiting it and saying, we now remember through absence what this place means to us. Though its lifespan was short, we're going to remember it. What I'm trying to suggest is, as we talk about the ahus on the summit, the kinds of sensibilities and attachments that we can expect will come into play if those sites are threatened. Okay, so this case has been to the state Supreme Court in Hawaii once, and it's on its way back this next month. So in the first case, there had been an administrative procedure called a contested case hearing. This is through the state land department. And it was for the purpose of assessing customary and traditional rights of Native Hawaiians. Would they be violated if the telescope's built? And if violated, what would reasonable mitigation measures be? That's the point of the contested case hearing. So the state land department said, okay, we'll hold that, but we're going to issue the permit in the meantime. So the activists went to the state Supreme Court and said, what? That's clearly a broken process. You can't tell us you're going to have a hearing, but initiate the permit. So the state Supreme Court heard this in 2015, and they said, yeah, that's right. We remand it. There needs to be a new contested case hearing. You put the cart before the horse. You must have a full hearing first. We'll put a hold on the permit, or vacate it, actually. So it went into a year-long contested case process where the demand from the court back to the State Department, Land Department was, make sure this is fair and has the appearance of fairness, both. So what I want to ask is, what does that mean when applied to the question of tradition? How does one fairly assess tradition? So I ended up being a witness in the contested case hearing because I had seen these ahus built, consecrated, and so forth, and people knew I was on the mountain. I was approached, would I speak to the religious action I saw? And I did. I can say more about in the Q&A. It was a strange experience. The state and the telescope attorneys, they had a whole bench of attorneys, and they were rough, and I learned a lot about exposure and other kinds of things. But still, I'm glad I did it. But it caused me to pay close attention to what was going on, and subsequently, and to ask myself, why is this failing so badly? And that's been my motivation. By the way, if you don't like me and you wish to pick a fight, just consider some of my friends here. On a pound-for-pound basis, really, is what I'm talking about. So this contested case hearing on remand lasted a year. There were 44 full days of testimony. You can find it all online. This past summer, the hearing officer issued her findings of fact, conclusions of law and decision and order, which was cut and pasted almost directly from the telescope's attorneys. It was really extraordinary. Almost no measuring at all of the traditional claims. Not even to then dismiss them or to offer mitigation, just said no, they're all contemporary practices, or they're inauthentic, they're merely political. So all these prayers, all these chants, consecrations, all who got lumped as not religion, not protectable by way of the state constitution. The state accepts this recommendation, and now the petitioners have appealed directly to the state Supreme Court. And I'd like to talk about this in the question period because it baffles me. During this protest period, the state legislature passed a law removing the appellate step for contested cases. They go straight to the Supreme Court. Seems like a broken mechanism to me. So now, in the real-time present, we're headed back to the Supreme Court. Two cases, one has to do with the sublease, one on the land use permit. It's that I'll focus on here in my remaining comments. And the land use permit is the one that takes up the question of tradition. Has tradition been, is tradition active on the mountain, and need it be protected, and if so, in what ways? And we're going to go back to our ahu as our central example. Why the ahus? As I've already explained, they're historically fraught, continuous with a deep tradition. They really stand emblematic for the way in which religion and politics have never been separate in Hawaii. Probably nowhere, for that matter, of course. But in Hawaii, always connected to battles, to land claims, so forth. And that's true today. They're also sites of what we would call everyday religion. Simple offerings of prayers, a chant, meditation. So what can we expect by way of the ahu in this process? Well, here they are on the day they were built. This is William Freitas, pro se petitioner in this case. Just after having built the ahu with a number of other young people, he's there singing to it, addressing it, asking it to come to life and honor them and to help them. This is Maui in the background, by the way, Haleakala. So the petitioners could rightly say, well, it seems like we have some protections going into this. What do those protections look like for tradition, for the ahu? Well, there's the federal constitution, First Amendment. There are various procedures and policies and laws relative to Native Americans, American Indian Religious Freedom Act, and so forth that might be appealed to. So some possible hope there, right? There's the state constitution that I'll go into in a minute that offers robust hope. There's my favorite word again. Robust legal history with some modest victories in Hawaii. That is, the state constitution provisions about tradition have been tested repeatedly, and sometimes there have been victories. So there's an appearance of a workable apparatus. State Constitution 12.7 in particular, this is a constitutional convention paragraph from 1978, right in the midst of the Hawaiian Renaissance. Hawaiian canoeing, chanting, language had all come back in the 1970s. And the state responded by saying, well, we need to honor these rights at the level of constitutional frameworks. The state reaffirms and shall protect all rights customarily and traditionally exercised for subsistence, cultural and religious purposes, and possessed by aha pua'a, that's a land segment, tenants who are descendants of Native Hawaiians who inhabited the islands prior to the dismemberment of Captain James Cook in 1778, subject to the right of the state to regulate such rights. So if there's such a workable framework and it's constitutionally embedded, what's the problem? Well, time, space, reasonableness, politics, these are some of the problems. And I want to parse these. That's the core of what we're doing here, and then we'll bring it to questions. Time, the time problem. Tradition, in the sense being practiced on Mauna Kea, exists out of time by way of the state's ability to see it. What do I mean by that? Previous test case about the tradition paragraph, 12.7. If we look at those, what we find out is traditional rights are protected if they're about subsistence, people entering land or the water to take something, but not in a way that creates an ongoing burden on anybody. Or triggers burial protections. In Hawaii, there is a very strong burial law. And I want to thumbs up to the state of Hawaii there. They've done that part right. So human remains get treated well, reasonably, and in line with the United Nations Declaration on the Rights of Indigenous Peoples. Or what else gets protected is what I'm calling merely ephemeral religion, no-cost religion of people showing up, doing a ritual, then leaving, or some other form of ritualizing that doesn't impinge on anybody else's claims, particularly claims to place. So, however, if traditional practices involve claims upon places and constrain other uses of them, I'm sure this sounds familiar, this is classic formulation, then rights are circumscribed through temporal confinement. So what I mean by that, temporal confinement, is traditional, if it has to do with land, if one looks at the cases, should trigger the constitutional protections, at least that's how I view it, gets elided with the word historic in practice, procedurally. Where does the word historic come from? It comes from the burial law, state implementation of burial law, that burials that are 50 years old or older shall receive protection. So somehow this gets elided to be relevant to living traditions as well, creating an impossibility. How can they live if there's a 50-year bracket around their very possibility? And it runs contra to legislative intent that historic, in this sense, should be the barometer. And functionally, what it does is it makes archaeologists the sole experts to assess living tradition. Native peoples aren't taken seriously about the meaning of their own tradition. Archaeologists are brought in, and archaeologists testify, well, I can only say I saw it if I did see it empirically. Otherwise, that's the only test I have. It leads to an absolutely nonsensical scenario where contemporary practices are absolutely invisible. So the hearing officer said as much. She said the ahu and other related practices on the mountain do not qualify for constitutional protection as traditional and customary, but may in 50 years. That is, should they survive the 50-year test, in 2065, come back, sure, probably traditional cultural properties. Oh, okay. Not much solace, let me say. So the problem, one we're familiar with, I think, from other settings, is taking heritage to be about the historic. That tradition is about the past, and that if that becomes the optic and metric for seeing and evaluating tradition, then it means that religion must be neutral, neutered, non-dramatic, and so forth, or only in the historic past. So things like innovation, plasticity, political engagement are indexed as inauthentic, invented, and the future of indigeneity is limited accordingly. So the space problem. So time is off the table. What about space? Here, claims are less about tradition. They're cast in the idiom of religion. What happens when we talk about Native Hawaiian religion? Well, the attorneys for the opposition came in right away and said, well, never mind that we're going to ignore federal consultative guidelines. We're going to appeal to federal notions of establishment. if you build these ahus, the state will be in a position of religious servitude. So it can't be done. So that gets invoked. They're okay if they're in the register of belief and have no cost to anybody. But if suddenly place-based, then we have a problem. I got ahead of myself. So here it is, the Establishment Clause, the attorneys and then the hearing officer really have an outside notion of the Establishment Clause, that any such action, if acknowledged, forget mitigation, forget compromise negotiation, if acknowledged at all, will make the state, put the state in a position of religious servitude. Then invoked also was the Ling decision. The 1988 SCOTUS case, U.S. federal government, it's a land claim case in California you may be familiar with. The punchline here being, at the end of the day, the government can do what it wishes with what's its land. So keep sovereignty and history of disposition completely off the table. Not to mention some other issues about burden and so forth. So even so say these petitioners can get past the problem of time and the problem of space, what else do they have to contend with? Mitigation. So repeatedly, the telescope promoters talked about mitigation, and the state seemed to embrace this notion that any form of mitigation would be fine. So even if these religious objects were found to be traditional, constitutionally protectable and so forth, even so, mitigation would be a reasonable answer. Okay, fair enough, we have to get somewhere. So what would the mitigation look like? Hawaiian-themed furniture in the telescope lobby. I kid you not. The Hawaiians were so incensed by this. It's like, it's a caricature of the lowest blows of colonial history, right? Really? That's what you're gonna do? You're gonna offer us furniture on what you think Hawaiians would want? More seriously, I mean, I'm perfectly serious about it, it's real, but in addition, several $1 million channeled into Hawaiian public school systems, but not on an ongoing basis, kind of a one-time deal, but still something that might be built upon as a site of negotiation. But the point here being that mitigation, no matter how much these things might be considered traditional, they can still be mitigated in any number of ways. Beyond that, other problems. The state said, well, for negotiation to take place at all, the religion in question has to be reasonable. They point to a case called Hanapi. Only reasonable religion deserves accommodation, is the language. Well, what, I submit as a scholar of religion, what is reasonable religion? With all due respect to religion, it's not reasonable, ever. That's why it's religion. Reasonable in the sense that they mean here. Right? I mean, it's almost by definition that where we go when reason fails. And it's never going to look good to anyone else from a different point of view, right? It assumes a different world. So that's binding in certain kinds of ways. And then the merely political. And the hearing officer said this repeatedly with regard to the ahus. They're just merely, blatantly political. And if they're merely political, they don't trigger any kind of protection. So she said, with specific regard to the ahus, it would yield an absurd result to protect them by way of the state constitution, that, that Hawaiian practitioners could exercise veto power over the use of land. To which, seeing this coming, some of the practitioners said, wait a second. We don't have infinite resources. We don't have infinite will. We chose this spot for this ahu because it matters that much within our tradition, that it's that threatened. We're not going to challenge each and every development project, and we haven't in the past. So, let's talk about a real world rather than an imagined one. So my response is to say it's equally absurd when the state claims to protect religious practices, but insists that they exist out of time, occur in demarcated spaces and not in others, and are reasonably apolitical. So pulling back out a bit, of course, these kinds of problems are really well known in other places, and I know you've all grappled with similar kinds of issues here. And with regard to religion in general, as Winifred Sullivan and others have argued, maybe freedom of religion is impossible for some of these kinds of reasons. But still, so long as religion and tradition are embedded in constitutions as things worthy of protection, We need to grapple with these issues, and how to do so with regard to land-based Indigenous traditions remains just a tremendous puzzle. As I mentioned, this is headed back into the state Supreme Court this next month. Hopefully the court will see that there is a real problem here between their stated principles of protecting tradition and their inability to do so through their administrative mechanisms. Really hope that gains some traction. But there was a recent parallel case from Maui, and the court didn't offer much hope in that. So if Hawaiians don't gain anything in this next round of hearings, what I worry about is this, probably an obvious point. A lot of Hawaiians have become invested in this process. They've engaged the state. They've given up lots of time and energy to deal with the state on its terms as citizens. Now they stand to be marginalized. And Hawaii is a pretty radicalized place already. There's a huge movement in Hawaii called the Kingdom Movement of people returning to the idea of the sovereign kingdom, and people who wish to just step outside of the state in all kinds of different ways. And so basic point that the conjuncture of vitalized religious traditions, as we saw exploding on Mauna Kea, with subsequent alienation from the state because that religious tradition wasn't taken stock of at all, can lead to radicalized religion. And I hope we don't see that, but it's hard to imagine it won't go that direction right now. Something else that's happened, I'm about to end. Along the way, the sides have become reified or entrenched. And this is, as common as dirt, right? That the sides in a legal battle paint black and white caricatures of themselves. What's really unfortunate from the Native Hawaiian side is more moderate voices within the community who are willing to talk about negotiation, to talk about a settlement, to talk about could there be a part of Mauna Kea set aside for our practices. Those voices are sidelined. It's all or nothing. And it's also true of the telescope developers. They're like, we have good attorneys, we have lots of money, we're winning this thing. So the chances for real conversation have been diminished almost daily, it seems to me, and that's heartbreaking. For now, kapu aloha continues to rule, this notion of nonviolent direct action, and Hawaiians really challenge them to do that. Many times on the mountain I saw people just leave. That's the ethic, that if you feel violent, if you feel warlike, whatnot, you have to exempt yourself from that space. That abides. How long it will abide, I really don't know. So how are we doing on time? These are just the questions. Okay. Well, what I want to do is take it back to you all. I know I moved fast, and I know there are a lot of gaps in what I presented, so certainly welcome questions on details. But what I'm hoping to talk about is just ways forward. Is this truly an intractable problem? Are Hawaiians there's no way to get any of these practices a fair hearing, as it were? What are parallel cases in Canada? These kinds of things puzzling about. So I'll stop there and open it up. Yeah. Thanks.
So I have this microphone not to amplify, but just so that we can capture some conversation. So I'll keep my eyes out, just catch my eye, and I'll bring it to you. I'm going to start with the first hand I saw. And thanks, Greg, for opening it up, not just for questions on this, but for some sharing of experience and all of that as well.
Thank you for this, Greg. It was really, really great. And there's so many parallels with what is happening in Canada. I have a minute point question and then a broader one according to your invitation. I was wondering what, I don't really understand how rolling boulders on the road to create a more physical permanent barricade that's not a human barricade, if it's like, why is that inconsistent with the ethic of nonviolence if you're not rolling it on top of people, which it was my assumption. And more globally, I was wondering if people are starting, you mentioned UNDRIP briefly in the presentation, and there's a growing and very just beginning conversation in Canada about the possible role that UNDRIP could play in rebooting our Aboriginal law tests that are also very akin to what you highlighted there about traditional and historic having to be frozen in the past, having to go back to a long time, in our case pre-contact usually, or pre-assertion of Canadian sovereignty. And there's just really interesting thinking about how Canada signing on or adopting UNDRIP can help us maybe reboot those tests and change the jurisprudence by basically saying, that was then, we have UNDRIP now, we're going to change the jurisprudence. Is that a conversation that's starting in Hawaii as well?
Yeah, great question on both, thanks. Briefly on the boulders, not everyone in the community thought that was an act of violence or a breach of Kapua Aloha. In fact, people talked about how the boulders spoke to them, and this was what nature was going to do to help them in their cause, so religiously framed. But I think the majority perspective saw right away how the state was going to frame it, how the newspapers were framing it. Native Hawaiians destroying their own sacred mountain. You know, look at what happens. This is, in fact, how the papers talked about it the very next day. Fragile alpine environments being destroyed by young punks kind of thing. And so to react to that, they self-policed in saying that was a misstep. And then the state claimed that it created an unsafe environment, and so they closed the mountain to everybody, saying, you know, emergency rule, basically strip everyone of their rights to go up there. And a special hearing was held on this. And then it was found that the state needed to open the road again. But I think it was basically damage control for the sake of perception in the press elsewhere that Hawaiians said that's not what we want to do on the mountain. As far as UNDRIP, there are quite a few conversations in American Indian communities, as you know, about this, and I think there are real hopeful moments, particularly around consultation and free, prior, and informed consent, this being sort of the gold standard. In Hawaii, it's a mixed thing. Some Hawaiians are attentive to the UNDRIP. They certainly know about it. They've gone to Geneva and New York. But a lot of Hawaiians say, you know what? The UN model and the UNDRIP are predicated on the idea that we're colonized people. We're a kingdom. We don't negotiate. This isn't a framework for us. We want our maximal sovereignty. We don't want to have to work through some other nation states and sort of what the UN model would seem to presuppose from their perspective. That's how they frame it. That it's yet another colonial mechanism that they don't want to be beholden to. Other Hawaiians have appealed to the World Court, and they've not gotten very far.
Thank you so much. That was really fascinating for so many reasons. I have a question about one phrase on that slide right there, and then another question about when you mentioned that idea of I'll see you in 60 years or 50 years or something.
50, yeah.
The first one, I was just wondering if you had any reflections about how using the phrase customary rights is going as a phrase, because I just provide the reflection to you, the communities and nations I'm getting to know or know already have just found that over time it seemed helpful to distance oneself from the word customary because it accidentally others stuff, like the capital O othering, and that instead that might be a moment where sort of the synonym Indigenous laws is helpful for just sort of putting some meat on the bones to sort of push back at people to who might be trying to say, well, that's just a habit and it's not a necessity, and isn't that interesting, and sort of sounding accidentally or purposely pejorative when they're responding to the idea of customs. So, and I guess I've seen sort of a trend at the Supreme Court of Canada that whereas the court used to talk about customary law, it then got changed to Indian law and then got changed to Aboriginal law, and now it's Indigenous law. So there's sort of been some synonymizing. I know that's not a word, but I'd sort of ask for your views on that idea of what happens when Indigenous people use the word custom, like what's the response? And the one, when you said that idea of the, we'll see you in some decades. One of the things that has happened in Canada, and maybe then it's connected to the final point in your slide there, is the idea of, has an Indigenous party given something up voluntarily? And if they have not given it up voluntarily, the time has continued to pass. So it's sort of, and I'm not sure that much thought was put into that possible opening by the Supreme Court when it wrote that, but it sort of had a bit of a sort of acknowledgement that there would be moments in history where a community or nation would say, you might think we stopped something, and you might think we thought it was unimportant, but it's because the Indian Act was forced on us or something, or we had to move or something like that. So that's another way to sort of keep the clock ticking, is to sort of talk about state impositions, that if those impositions had not been there, you wouldn't have to worry about that. I'll see you in 50 years. You could actually backdate it. And perhaps that sounds a bit compromising to court standards, but it's been a bit of a way for folks to talk about that the courts need to understand how many mechanisms were on top of the Indigenous parties to stop something, you know, whether it's a dance or an annual event or something, that otherwise they would have continued to go on with that. So anyway.
Yeah, thank you. I hope that if the state Supreme Court really does pick up on this tension, tries to work it through, that they'll be open to, clearly the administrative procedures to be more just will need to be rethought. And it may be along some of the lines you're suggesting, those could be opportunities. For now, the language problem is so real. So the question of customary that you raise, we learned right away. My scholarship's all about what I call living tradition. And I sometimes use as a synonym contemporary traditions, just to emphasize happening here and now. And my Hawaiian friends, before I testified, said, don't say contemporary, just don't say contemporary, because that doesn't trigger anything. And in fact, it gives exactly the wrong impression. So whenever possible, say customary, say traditional. So there's this policing of language around the categories of law, trying to avoid the contemporary. But now my point is that tradition and customary aren't doing any better functionally. So there has to be a better way forward. But this is, I guess I'm just trying to pinpoint the dynamic where within the community, this language has been embraced and policed. And they too will need to rethink these categories, or there's not going to be much movement. And I think the Indigenous laws framework is really hopeful. There is, in Hawaii law, there are gestures to the kingdom laws from before, and saying it's reasonable to think of a continuity between the Hawaiian kingdom and the state of Hawaii, and let's draw best practices forward from that prior time. So maybe that could be looked to with fresh eyes. And I think what you're saying here is hopeful, so long as the Supreme Court creates space for these conversations. Yeah, thank you. That was great.
Hi. Thank you so much. That was really interesting.
Oh, thanks.
I had one quick question.
Yeah, please.
I was wondering, I'm not sure if I understood this correctly, but I was wondering, so the ahu seems to symbolize a belief, like a sacred belief that they have in that area of the mountain where they built it. And I'm wondering if there were discussions in the past or that come up in this case in Hawaii around intangible cultural heritage, but and also around spiritual beliefs in land that don't have a tangible reflection. So there's no structure, because it was interesting to me that they built something as if to showcase what no one else would recognize is just a belief because they can't see it.
Yeah, great question. This is so much at the heart of it. So in previous Hawaiian traditions, the summit of Mauna Kea was regarded as the realm of the gods or the realm of the spirits, and humans weren't supposed to go there. Only the most elite of the elite, or the chiefs and others, would go for visionary purposes and so forth, but not stay there, not build there, so forth. So some Hawaiians who are on the other side of this, and certainly the state of Hawaii, say, look, all this stuff, the ahu, the building, that's all mumbo jumbo. That's not in continuity with a prior tradition. The people who built the ahu would respond to say, when the mountain was cared for, when it was safe, we didn't have an obligation to do anything here. Our obligation was to stay away. Now that it's threatened, that triggers our obligation to protect it. And how we protect it is through creating a ritual focal point, the ahu, where we come and pray to it and honor it. So what you're calling merely political, that is that we built something on the very footprint of where you intend to build, is actually for us a religious obligation of the highest order to protect. And it can be pretty well demonstrated throughout Hawaiian history these kinds of things have happened. Whether that should create veto power or not is another question. But to the absence question always bedevils Indigenous peoples. Why you say this was yours, but nobody's here? Nothing's here. Right, because that's how it was intended to be. But if called to protect, then the terms change. That makes sense? Yeah.
Hi.
Yeah.
Several years ago, I worked on these issues in a Canadian context, and one of the issues that came up is that, whether it be a telescope or Oka or some of the bigger ticket, higher profile ones, the more common and prosaic examples are actually in the context of land development, building of subdivisions,
Yeah.
regular highways, those sorts of things. And what often happens is that there is no, you don't get to the consultation question, you don't get to the acknowledgement of religion question, because things are just turned up in the context of building a subdivision without anyone knowing, without government regulators having any notice of it, without Indigenous organizations having any sense that that's actually what's going on. So in that context, it's more, in addition to being a religion question, it's also a land development question. And I'm just wondering from your experience what sort of insights you may have to try to tackle those prosaic examples in addition to the higher profile ones.
I appreciate the question. In Hawaii, in just practical terms, that's frequently been resolved through the state burial law. Most places where there's development in Hawaii, because the land base is so small and so unbuildable over much of it, the lava fields and so forth, the buildable areas are the self-same places where Hawaiians for generations have buried their dead. And the state burial law, as I mentioned, is quite robust. So there are, every island has its own burial council, a majority of Native Hawaiian cultural practitioners, and then development representatives and so forth. And they, on a case-by-case basis for each development, puzzle out what's going to happen. Will the burials remain in situ? Will they be moved? Does the project need to stop altogether? And it's been, people were skeptical when the law was passed in, I believe, 89 or 90. But we can say now, some 30 years out or whatever it is, that it's working. It's really a shining example. Hawaiians have considerable agency over what happens to land in general, and there are very few development cases that I'm familiar with that Hawaiians have tried to stop that didn't involve burial sites. Their geothermal projects on Hawaii Island are an exception, and religious claims were made in that case. But then I think ultimately the legal process didn't go all the way through. I think the developers pulled out. I'm not totally sure about that. I'll have to look into it. Yeah, that's the best I can do there.
Oh, I think I'm next. Thank you very much. In fact, my question really carries on from there. You have a lot of lovely turns of phrase in your talk, and one of them was the question of sort of like seeing like a state, what the state can see and when it cannot see. And I guess my question was, why is the Hawaiian state, not the Hawaiian kingdom, but the Hawaiian state, able to see in the context of burial claims? I mean, there might be a really simple answer to that, but is there something in the way that process has worked that could be transferred to the customary, contemporary, the rituals that one can't see that would be helpful? I'm sure people have thought about this. I mean, I think the other turn of phrase that really shows the problem is that, yeah, no cost religion is fine, but religion that actually claims place is not. But it would seem that in the burial case, it isn't no cost religion. So I just want to hear you reflect on that a little bit.
Yeah, no, thanks. That's a good tension to point out. Thank you. I hope there are lessons to be learned from the success of the burial law administration to cases like this. That bridge work needs to be there. It's not there. I think there are victories to build upon there from a Native Hawaiian perspective. But there are also worries about abuses. One such abuse is the very ahu that we've been talking about. Shortly after it was built, one Hawaiian activist took it upon himself to relocate his grandmother into it to trigger state burial law. Some of his allies found that reasonable, and there are examples in Hawaiian tradition of moving bones for the sake of marking space. calling on the ancestors through their iwi, their bones, to be there. There are precedents for that. Others said, geez, that makes a mockery of the burial law. And surely we don't want to trade against the integrity of a process we fought so hard for. And that was the prevailing view. It got quite ugly in the community. But I have to think you're onto something, Pamela, that the burial law, because of its successes, if I'm right about that, and I think I'm right about that, must offer something up here. But part of the problem is getting past the mechanical piece of the historic framework that enables so much of the burial law. I'm just going to say I'm grateful for pushing me to think about that. I don't have a better answer right now. Yeah, I think that may be a possible way forward. And just one last thought on that. Part of why they've succeeded so much is public outrage with the burial law. In 1988, at a place called Honokohua on Maui, 1,100 sets of human remains were disinterred from what would be a parking lot for a Ritz-Carlton hotel. And at first, it was just a handful of human remains, and the state said, oh, we can mitigate, we can move, we can preserve and see. By the time it was 1,100, and there was no burial law in the books. The federal legislation about burial law was just in the works. But the public outcry was extraordinary. There was a Hawaiian governor at the time, John Waihee, and he used his might, and a state burial law was passed pretty quickly. People just saying, this is the magnitude. And Hawaiians are saying, our ancestors are calling us to do something. And I think non-Hawaiians in Hawaii recognized, yeah, wow, there are other places to build. We do need to have a way to have integrity here.
So I would just want to put in a question or two, and then there's these three people I've seen. So Greg, I'm just interested in a question about the use of the language of religion in the communities you're dealing with. And I guess my question is, what you think set that in motion? So is it that there are categories of religion in law that are being appealed to by framing things in matters of religion? Are communities understanding kind of endogenously, or is this a mistaken kind of question, what they're up to as religion? And what I'm thinking about here is there's, a resistance, and in Canada we've just been dealing with this question of a move from sort of Indigenous rights and title to this case that's come before the Supreme Court and has been decided, where religion and freedom of religion gets turned to. And there are reasons for, I think, the turning to freedom of religion there. So I guess my question there is, what has put the category of religion in motion? Is it the community saying you're dealing in our religion? Or is it kind of legal categories trying to make sense of practices? So that's one kind of question. And the other one was how this is there any kind of economy or interplay with religion claims outside the Hawaiian religion context? So what are the dynamics, for example, with others in Hawaii or in the US that are making arguments about freedom of religion? So there must be communities in Hawaii as well that are making claims from Christianity or other sorts of, that's saying, yeah, you're right, you got to take religion super seriously. And the Hawaiian case is an example kind of in their own politics with the state. Are there any of those kinds of relations that are in play that are kind of touching on the Hawaii example?
Great, thanks. The religion question is kind of perplexing to me because I've been working there for 20-something years, and for sure in the first decade of working there, I learned religion was not the right word for me to use to explain to people there what I was interested in. I learned that the idiom is tradition, culture, or various Hawaiian words for the same, but not a category of religion. There's not something that really translates very well. And so I became surprised in the Mauna Kea case in particular when suddenly religion was the discourse, the category, and so forth. And I haven't yet figured out so much what's going on there. I think part of what's going on is some people, most of the petitioners and interveners are pro se, they're self-representing. But there are a few attorneys on the edges, and I think and some of them are hacks, and that have said, well, you really ought to try to leverage your First Amendment rights. Not being really cognizant of the bad history of federal Indian law and the Ling decision and so forth, but surely this is a religious freedom. You're American citizens, whether you like it or not, you might as well leverage this. And so the idiom shifts to religion, and then they bear the costs of it. I don't think it's worked, but I think that's part of it. I think another part of it is in the broader US framework over the last several decades, watching what's happened with the restoration of religious freedom acts, and in particular strange cases like Hobby Lobby and some others, this general sensibility that, The government's honoring religion, some people's religion, some of the time. But if they're going to honor it, let's ask them to honor ours too, something along those lines. And adding to that, this is where it gets really weird. Jeff Sessions issued a memo back in the fall of this past year, 2017, the Attorney General, saying all agencies of the U.S. government and state agencies need to review their administrative policies to make sure they're in line with the highest ideals of religious freedom. So right now, there's a conversation among some of the petitioners in the Supreme Court case. Do we flag that? Do we try to put that before the state of Hawaii Supreme Court, this mandate? Hate to get in bed with those guys, basically, is the sensibility. But if they're creating greater room or scrutiny for religious freedom claims in a positive way, this could be good. So we'll see where that goes. I don't think those are very full answers to your question, but.
Yeah, I was just curious about the Ahus
Yeah.
that were contesting the land at the telescope area, and I was wondering if there were different levels of their sanctity, because in the sense that that telescope is it's not a commercial operation like the Ritz-Carlton. It's in itself sacred. It's made for science, and it's not like an old telescope. It's like the newest version of its kind. I'm sure it was hard to get it there. There's a bidding process. There were international actors.
Yeah.
So I was wondering if there's a similar level of sacredness levels with Ahus, and if the indigenous people are willing to actually make that distinction on their own and make changes just for negotiation purposes.
Yeah, I hear you. It's a great question, and this thing I closed with by saying that the sides have become quite reified, that's unfortunate, because there are voices in the community saying, you know what, we do have histories of Ahus being built and then relocated, or negotiating just about everything we need to, so long as we have integrity in how we proceed. There are those voices out there. Or just even to insist that, okay, the telescope could be built, but the Ahu remains. Some days the mountain will be closed for ceremonial purposes. A part of the whole mountain will be open for Hawaiians only. These kinds of negotiations have been floated, but they usually get shouted down, because right now it's a maximal black and white struggle. And I tell you, it's heartbreaking. My own investment is to see that Hawaiian tradition receive some protection under the law, but I'd like to see the people who built the Ahus and others feel like they were heard and there was a reasonable outcome. Reasonable, there I am using that language. But right now it just feels like the sides are so entrenched that the state's probably going to affirm this. The Ahu will be bulldozed, and that's what'll happen. It's hard to imagine otherwise. One thing that might happen is the TMT Corporation has repeatedly said this process is taking too long, that they're seeking an alternative site. It's in the Canary Islands, and they're going to move forward on that. And lots of Hawaiians are saying, good, let's just keep dragging this out. But it seems like a bluff to me. They've invested so much. I think that's just a way of lighting a fire under the government to speed things ahead. But your basic point about, are these things negotiable? Are there different kinds of Ahus or ways of imagining? Absolutely. Unfortunately, that conversation is not happening right now.
I'm certainly more familiar with the Canadian legislation, legal dealings and all that. But I was just hoping you could talk more about how the state in Hawaii treats the land that is recognized as belonging to the indigenous population there, sort of both in terms of percentage or proportion of land that is recognized, and also sort of what activities the state would allow to happen on that land.
That's a great question. I'm not a land use expert, and so not even in Hawaii, so I can't give you a great answer there. What I can say is there's nothing comparable to reservations as in the United States or reserves as here. No such land status. There's a status of land called Hawaiian homelands lands. These are mostly subdivisions and houses, sometimes larger plots, but basically residential communities. Then there's an entire category of undeveloped so-called crown lands that, on one reading of the history, these are trust lands set aside for Native Hawaiian use, but in practice it doesn't amount to much, and the state regularly dips into the crown lands for its own purposes. So I think Hawaiians are fairly cynical about what that crown land means for them. But this is part of why the kingdom position is getting so strong. They say, look, our kingdom, in theory, this crown, we possess title of a kind to millions and millions and millions of dollars worth of land. We should assert that. The simple fact of the United States military being so present in Hawaii is a big monkey wrench in all of this. The military basically plays the proverbial trump card as often as it wants, and that's a real consideration. What Hawaiians do have, I mentioned in one slide, are fairly robust subsistence rights, at least. They can go into the ocean anywhere. There are no private beaches in Hawaii. They can harvest in ways other people can't. They can hunt without licenses for the most part. These kinds of subsistence rights. But you've put your finger on a debate. Lots of Hawaiians are saying, okay, well, let's protect Mauna Kea, let's protect burial, so forth. But how about our daily lives? Surely there should be better resources for Hawaiian to be Hawaiians. And it's not there right now.
So in the picture of the Ahu, there were 2 other telescopes behind. So I got curious and Googled whether there were other telescopes that were built upon. There are 12 in Mauna Kea. So what is so special about TMT? Is there something symbolically more significant regarding the area that's going to be built?
This is actually a major issue before the court. The notion of cumulative impact versus one instance of impact, because the state just says, for better or for worse, there are already 12 telescopes up there. This doesn't make a categorically different kind of impact. Hawaiians' response say, yeah, actually, it's way bigger. It's 200 feet tall, or just about. It will be quite large and quite visible. But beyond that, they say, hey, let's look back at history. Those other telescopes, they were built in the 70s and 80s for the most part, or that's when the permitting was done, as the Hawaiian Renaissance was just finding its legs, before the immersion school kids came out of school, before the state constitution had any traction in the courts. The ground has shifted. We Native Hawaiians, we speak our own language now. We practice ritual on this mountain. And so our elders were less successful in trying to stop the other telescopes. There is a historical record that people did try. It just wasn't so visible. But now you have to contend with us as we are in this moment of vitalized tradition. That's the response. The state has negotiated a little here. They've said there will be no further development, no new pads or telescope sites, that any new telescopes post-TMT will require the deconstruction of existing telescopes. So, I mean, that's to me, that's a meaningful bit of negotiation, but most of the Hawaiians I work with are like, whatever, no, that's not good. That's not good enough. But it's a very trippy landscape. The telescopes are all over, and you can imagine the amount of money and vehicles and government operations. It's a really intense place that way. The juxtaposition of alpine landscape and high technology. But most of the Hawaiians I work with, they're not anti-science or anti-telescope. Just to be clear, it's that they're against having their consultation rights failed so miserably.
Yeah, I'm curious about the idea of mitigation. It's not, or to mitigate, it's not like a legal concept I'm familiar with, and I'm wondering if it is, and how similar that is to an idea of accommodation, and to what extent mitigation in this case would entail some sort of either inference or recognition that there has been an infringement of tradition or religious freedom rights.
Well, that's great. The way you end that is, I think, the real issue here, that if something's to be meaningfully mitigated, it has to be for a reason. That involves some sort of a concession or acknowledgement. And I think based on the hearing officer's reckoning of things, the state doesn't see any reason to have to even propose mitigation. There's no fault there. Is it a term of law in Hawaii? I believe so, but mostly I'm familiar with it through administrative procedural issues. So the last part of the state constitutional provision, 12.7, says, subject to the state's right to regulate traditional and customary practices. And then a subset of that administratively, as it plays out, is reasonable mitigation. And reasonable mitigation can include, moving something, offering an alternative, and that alternative can be something like educational funding, having nothing to do with the physical thing, but some meaningful, alternative. That's how it plays out. And the Hawaiian response on the ground basically has been, that's all the shell game to us. No amount of educational funding is going to preserve the sacrality of our mountain forests. And so I guess insofar as you take a look at the Supreme Court case as it unfolds, watch along with me to see what the mitigation language becomes and whether the court grabs onto that and does something with it or not. I genuinely don't know. Yeah.
Well, everyone, I hope we'll have a few minutes that you can come up and ask Greg some further questions, but I have to bury him in swag right now. And
Dude, how cool is that? Hey, awesome.
Got us thinking about things that are obviously in new ways and with the work that Comparison does. I really appreciate it, and we'll walk out thinking kind of more deeply and richly about these things. Thanks so much for coming. That was a lot of fun.
Thank you guys. Thank you all. I really appreciate it. Thanks. Awesome.